right. Good evening, ladies and gentlemen. I'd like to call to order the special meeting of the Development Commission discussing the Issaquah Highlands Retail Site Development Permit, the Issaquah Highlands Medical Office Administrative Site Development Permit, and the Issaquah Highlands Self-Storage Administrative Site Development Permit. I think where we are process-wise is that Mr. Lell is going to begin his cross-examination of the applicant's witness.
And just before we begin, as a clarification, Ray provided binders to the Development Commission updated from yesterday, so you should have a full set in front of you.
Thank you.
Thanks.
I'm hiding behind these binders.
Good evening, Ms. Heim.
Hi.
Could you please verify that you continue to be under oath from your prior testimony?
I am.
Thank you. Have you been present for all the testimony and argument in this public hearing?
I have.
Your counsel, Mr. Schneider, stated during his opening statement that you, quote, took careful notes, end quote, of your various meetings with city staff members. Do you remember that statement?
Yes.
You also indicated in your own testimony previously that you kept notes during some of the meetings that you had with city officials. Is that correct?
Yes.
Were these the same notes or minutes that were provided to me by your counsel, Ms. Carey, during the previous installment of this hearing?
Yes, the notes that she provided were notes that I took.
Could I please ask your counsel to provide you with a binder or folder that contains those notes?
They should be up there.
Great, thank you. At this point, I'd like to offer into evidence as a city exhibit the entirety of the note or minute package that Ms. Carey provided to City's Council during the, I believe, the January 15th hearing proceedings. And these are Ms.
The packet of the notes, I believe, it should be 257.
Jeff, you're not on the...
C57 would be the next exhibit in order, I believe.
I believe we have through 43 at this point, C43, but let me double check that.
That's probably right.
Okay.
I looked at the wrong book.
Yeah, that's what I have as well. I have that we have through C42, so this would be 43.
Okay.
Be 44, won't it?
43.
Yeah, we have 43.
We have the C43.
Yeah.
Yeah, actually, we have through C43, so this would be C44. Yeah.
We'll mark it as 44. I have extra copies for all of you.
Right. Sure, thank you.
Okay.
How did you maintain your notes, Ms. Heim?
How did I maintain them?
Yes, after taking them.
I'm not sure what you mean.
Did you maintain them on a computer? Did you maintain them in Word format? Did you maintain them as a PDF document?
Oh,
Binder?
I
How
think
did you
it
maintain your notes?
depends on which notes you're talking about. Some are handwritten, which obviously would have been in a file, and some are typed. So those were in Word document format, and some were in emails. So those are in emails.
Did you ever destroy any notes from any of your meetings with city staff?
I don't believe so.
Did you specifically inform city staff members that you would be taking notes during these meetings?
I don't know, but they saw me taking notes during all of the meetings.
Did anyone on the city staff ever comment regarding your note-taking?
No, no one ever objected.
I refer your attention, please, to Exhibit S55H. I can provide a copy if it's easier for you.
That might be faster, but let me see. Oh, this one.
For the record, this was an exhibit that had previously been introduced by Shelter in this proceeding. And it's identified as an email message from Jean Lynn to David Holmes with several courtesy copy recipients. Could you please read the highlighted portion of the substance of that email, beginning with "please note"?
I can, but I can also tell you that this email is not referring to notes that I took at a meeting. It's referring to notes that David took. Do you still want me to read it?
Please.
Please note that I have had a chance to review the minutes your team prepared for this meeting. While some statements were accurate, there were statements that either have not been verified or were not discussed in the meeting. For these reasons, I did not rely on those minutes. Our comments from the meeting are reflected in our comment letter.
Did Mr. Holmes provide any other notes or minutes of meetings with city staff, to city staff members after he took them, to your knowledge?
I don't know.
Did any other member of the Shelter applicant or consultant team provide copies of meeting minutes or notes to city staff members?
I don't know.
I believe you testified that you began working for Shelter in April 2015. Is that correct?
Yes.
The earliest meeting notes or minutes that were provided to City's Council during the previous hearing installment were from a January 21st, 2016 meeting with city staff. Did you have any previous meetings with the city before that date, your recollection, regarding the Shelter project?
I think probably.
Did you take any notes or prepare any minutes for those meetings?
I don't know.
I'd like you to, if you could, please turn to your meeting notes from the January 21st, 2016 meeting.
Okay.
When was this document created?
It would have been created either on the date of the meeting or shortly thereafter.
And the meeting notes indicate that the meeting was with Keith Niven of Issaquah. Were there any other city staff members in attendance at this meeting, to your recollection?
I don't believe so, because if there were, I would have noted it in the meeting minutes.
The purpose of this meeting to discuss entering into a new development agreement?
I think the purpose of this meeting was to discuss generally planning and development of our property, potentially extending or amending or a new development agreement would have been one of the topics that was discussed. That from very early on was something that was suggested by Director Niven.
Was that suggestion prior to this meeting or at the meeting?
I think the initial suggestions predate my involvement with this project. I think his initial conversations about development agreement started with Gary much earlier.
So you wouldn't have any firsthand knowledge regarding those prior meetings because they predated your time with Shelter, is that correct?
I'm not sure that's totally accurate. I don't have firsthand knowledge of meetings that predate my employment with Shelter. That's accurate.
Thank you. Could you please turn to page 2 of your January 21st, 2016 meeting minutes? Your notes there provide, and this is a quote, "There are old standards in the development agreement and the city will not allow you to continue to vest to those," end quote. Do you see that reference?
Yes.
Who stated that?
Mr. Niven. He was talking about, just to give you context, he was talking about if we were negotiating a new development agreement, that there were certain standards that the city felt were outdated and wouldn't be something that they would be interested in allowing us to continue to vest to. So the one that he gave was stormwater, because as you know, stormwater manuals get updated over time, and he thought that the city would want new development under a future development agreement to use a different stormwater manual.
Were there other development standards that Mr. Niven discussed in the context of vesting or non-vesting at this meeting?
I don't recall any other specific development standards that he gave as an example, but I think use of the term vesting in that context is a little bit misleading, because what he's referring to is what standards would have been carried over from the Issaquah Highlands development agreement to potentially a new development agreement. So he was using vest in that way, in carrying it from one existing agreement to another, not in the normal term
So
sense of vesting.
He was using vesting in a sense that's not traditional or legalistic in your understanding as a land use lawyer. Is that your understanding?
I would say it's not, he was using it in the sense that is not consistent with the vesting discussion that we've had throughout this hearing.
Thank you. Could I have you next turn, please, to your February 1st, 2016 meeting notes?
Okay.
And the fifth bullet point beginning with Keith explained. Could you please read that?
It says, Keith explained that if we do not extend or do a new development agreement, then the city will give us traditional zoning designation for our property. He's not sure what that would be.
And is that an accurate reflection of what Mr. Niven told you at that meeting, to your recollection?
I think that's one item that he told us at that meeting.
So based on that statement from Mr. Niven, you were aware as of February 1st, 2016, that the zoning would change on your property unless a new development agreement was reached, or the existing development agreement was affirmatively extended, correct?
No, I don't think that's accurate.
Could you please clarify?
I think that that statement is talking about what would happen with respect to our property on a very broad level with respect to the regulations that apply. So this statement doesn't, to me, say anything about ability to vest under the development agreement, which is another possibility that you didn't include in that question.
Okay, and my question wasn't specifically related to vesting per se. It was more going to the purpose and context of the bullet-pointed statement in your notes. Could you please then look at page 3 of the February 1st, 2016 meeting notes, in particular the 4th and 5th bullet points?
Okay.
Could you provide some context as to what was being discussed in those bullet points? And summarize what you understood Eric and Mr. Niven to be referring to?
I think that Eric was acknowledging that planning at the level that we're talking about for a 21-acre piece of property in the middle of a mostly developed master plan wouldn't necessarily be an easy process, and we didn't expect that it would be an easy process, but we did expect to work collaboratively with the city to try to come up with the best solution. And Keith was explaining from his perspective some of the challenges of negotiating a development agreement in Issaquah in particular.
With respect to the process potentially not being easy for either negotiating a new development agreement or obtaining an extension of the current one, were there specific timeframes or time estimates that were referenced in that discussion, to your recollection?
I would need to take a minute to review the notes to remember what was discussed in this particular meeting, but I do know that at various points of time within this time frame, Mr. Niven gave us different descriptions of what the process was to get to development agreement, and those had different time frames associated with them.
And do you recall approximately what those timeframes would have been?
No.
Could you then please turn to your February 25th, 2016 meeting notes?
Okay.
According to your notes, it indicates that this meeting was between yourself, Keith, and Emily Moon. Is that correct?
I believe that Gary and possibly Eric were there as well. Yeah, but Gary and Eric both were there as well.
Thank you. Is that apparent from the document somewhere? It's difficult for me to tell, given the addressee versus the indication of who was actually in attendance.
Yeah, if you look at the bullets, you'll see there are some that say Gary explained and Eric explained.
Thank you. Was this a collaborative meeting generally? Was it an amicable meeting?
I think generally, yes.
Is there anything in these meeting notes or in your own personal recollection that would indicate that this meeting was antagonistic at all or volatile, involved any type of any tempers flaring on either side?
I don't remember anything with tempers flaring in this meeting.
If the meeting had turned volatile or antagonistic, would that have been reflected in your notes?
Yeah, I mean, if it was extreme, then yes, probably.
What would you define as extreme, just for purposes of reference?
Probably somebody raising their voice, face turning red, threatening to leave a meeting, that kind of thing.
And again, to your knowledge, that didn't happen at this meeting?
Not that I recall.
In the second bullet point, there's a reference to needing support from the mayor's office first. Do you see that reference?
Yes.
Can you give me the context, please, for that statement? What did it mean to need support from the mayor's office, and what was at issue?
I think what Keith was advising us was that we needed to have both his and the mayor's support of any proposal to make it have a more smooth path forward.
Is it a fair characterization that Mr. Niven's comments and suggestions to you were aimed at facilitating a proposal by Shelter?
Yeah, I mean, I think that he was trying to walk through ideas as to how to get to some kind of solution. But he also, he was not able to, I think, give us very concrete direction on some of those items.
With respect to the reference to the mayor's office, who was the Issaquah mayor at the time of this meeting in February of 2016?
I believe that would have been Fred Butler.
Based upon Mr. Niven's recommendation, what efforts on behalf of Shelter did you make to follow his advice or his recommendation
His recommendation.
regarding getting support from the mayor's office and/or the council?
Oh, well, he advised that we needed to go to the community and get their support if we wanted to get administration and the mayor's buy-in on a different proposal that was something other than what was under the current development agreement. So based on that, we began the outreach that we did to the Issaquah Highlands community, which I think I described earlier, and it had involved several open houses, focus groups, bringing all of our consultants in to meet with the community and answer questions, take their feedback, and develop a plan based on that.
Did you recognize at the time of this meeting that any decision in this regard would be up to the city council? They would be the ultimate decision makers
Decision makers on what?
on a potential extension of a development agreement or a new development agreement or a modification of the classification of your property?
Yes.
Did Ms. Moon indicate that she would be supportive of IHIFC's proposal going forward at this meeting?
I'm not sure that we had a specific proposal at that point in time, so I'm not sure that she would have offered support of a proposal.
Did she indicate any type of opposition to any future option for the shelter property at that meeting?
I think she only asked us to have a more definitive proposal.
Could you then turn to your meeting notes for the May 18th, 2016 meeting?
Mm-hmm.
According to the attendee list, the persons in attendance at that meeting were Mr. Niven, Ms. Sloman, Mr. Young, Mr. Evans, and yourself.
Yes.
Correct? In the fourth bullet point, the hollow bullet point, under the first solid bullet point on page 1, reference to KN. KN made clear that the process is very fluid and they are sharing their current course, but are open to discussion and change in course if needed. Could you give me the context for that and explain what that was intended to mean?
Well, the city was briefing us on how they were going to approach the end of development agreements, which they were calling end of days. And Keith was explaining that they really hadn't gotten very far in the process of figuring out what that was going to look, what the zoning might look like that they were proposing after the development agreement.
Was there a discussion at this meeting regarding the future replacement regulations that would govern the Issaquah Highland area after the development agreement was terminated?
There was general discussion. I don't believe at this, well, hold on, let me look at my notes before I answer. So there was some discussion of their initial thoughts on the general approach, but there was no discussion on the specific replacement regulations because they hadn't been developed or drafted yet.
Did Mr. Niven indicate that that would likely be a work in progress for some time at this meeting?
I don't know if he spoke to timing. If there's something specific you want me to look at, you could point me to it.
I'm trying to find out more about the purpose and what was actually said at this gathering. Did Mr. Niven indicate that he was unsure where the council really was with respect to the wind down of the development agreements at this point in time?
Yes,
What did you interpret that to mean?
that he didn't know what the council had in mind with respect to the wind down of the development agreements.
Could you please look at the second solid bullet point on the second page of your meeting notes for that meeting, beginning with KN said?
Sorry, say that again, the second solid bullet point
Correct.
on
beginning
page
with,
2?
Page 2, KN said.
So he explained to us that the Talus developer was also asking about mitigation fees already paid and that the city didn't have an answer yet.
What's the Talus development or developer?
Talus is another master plan in the city of Issaquah, and initially the city combined Talus and Issaquah Highlands for purposes of drafting replacement regulations because they were terminating the two urban village developments at the same time, and had originally anticipated having the same set of regulations govern both areas. Later on in the process, they decided to split the two and treat them differently.
Turning to page 3 of your notes. The fifth solid bullet point, beginning with KN said. Could you read that, please?
Yeah, so this is one of the times that I referenced earlier tonight where he gave a different explanation. This is one of the explanations of how you would initiate a development agreement negotiation. So at this point in time, he said that if we were going to start a negotiation of a development agreement, we would need council approval. And that his opinion was it would be very prescriptive and might not allow the flexibility that we were looking for.
And skipping a bullet point, the next reference from Mr. Niven, KN said that if there is any resident support for Shelter's idea, then they need to reach out to council and be vocal because all council is hearing is negative. What did that mean in your understanding?
Well, we had some discussion about the fact that, council was hearing from people that didn't want development. And part of that discussion turned on the fact that anytime there's a development proposal, council or the city or the governing agency only hears typically from those that oppose it. If you like a project, you don't usually spend your evening in city council or development commission telling them how great it is. It's those that oppose. So we had some discussion on that,
But at
and
this
that's what
point,
that referred to.
If I understood your testimony, at this point, there was no specific proposal. Is that correct?
I think that was in February. There was no specific proposal. These notes are from May. And in May, we had gone out to the community and had our initial open house. And at our initial open house, there still was not a specific proposal. What we did at that open house was we brought all of our market research and our consultants on various issues that we thought people would be interested in. So what had been shared was market data about how much of each type of use could be supported in Issaquah Highlands. Some people definitely misunderstood that, for example, there was, the market study concluded that there was demand for up to 2,500 units of housing, additional housing in Issaquah Highlands. That was never what we were proposing, but that number was shared as what the demand would support, and so there were some people that were confused by that and were contacting the city.
Do you recall, were they coming to council meetings to express their views, or were they writing letters to council members? How was the council hearing this negative input?
I couldn't tell you all the ways that they hear from people in the community, because as an outside party, we don't have access to that. There is definitely a contingent that tends to show up at most Issaquah City Council meetings and express opinions that are typically against most things.
But to your knowledge or understanding and recollection, it was more than just one or two people that were expressing negative viewpoints at that stage?
I don't really have any context to answer that.
Fair enough. If I could have you please turn to your September 21st, 2016 meeting notes. This was a meeting attended, according to your notes, by Mr. Niven, Ms. Sloman, Patrick Mullaney, Gary Young, Eric Evans, and yourself. Is that correct?
Yes.
Can you please turn to page 2 of that document? And please read the 5th bullet point, beginning with Keith said.
Zach, before we get started, can you share the date one more time? So I don't
I'm
wanna-
sorry, it's September 21st, 2016, I believe.
Thank you.
That bullet point says, Keith said, all your mitigation will evaporate and disappear because the city's new concurrency system has no relevance to vested trips. However, he acknowledged that the city can't make landowners pay again something that the landowner has already paid for. So there might be some number of trips vested in the overlay, but they may be directional only.
So just to be clear, as of September 21st, 2016, Mr. Niven informed Shelter of the city's belief that it could not make landowners pay again for something that the landowner had already paid for. Is that your recollection of this meeting?
Yes, he made that statement on several occasions, and he made statements to the contrary on occasions as well.
Could you please scroll down to the 8th bullet point on page 2, beginning with Keith indicated? And please read that aloud.
Keith indicated that the solution for mitigation credit related to the DA will be similar to how the city addresses credits for the Talus property and Talus master developer Dan Hayes.
And the DA, just for reference, obviously refers to the development agreement, correct?
Yes.
And do you know how the city addressed credits for the Talus property and Talus master developer Dan Hayes?
I don't, but I believe the city is involved in a lawsuit with respect to, or a lawsuit or appeals with respect to the Talus development as well.
But Mr. Niven indicated, according to your notes, that there was a potential solution for mitigation credit under the development agreement, correct?
He indicated that the solution could be similar to how to a solution that they might come up with for Dan Hayes. There was no solution offered for either property at that time.
Thank you. Could you please turn to the top of page 4? The first bullet point beginning with Gary asked, and read that aloud, please.
Gary asked how Shelter can protect its current contractual rights. Keith responded that when the DA expires, Shelter will lose its contractual rights, and the city council will zone Shelter's property. Keith said at that point, Shelter would be at the whim of council.
It's your testimony, Ms. Heim, as reflected in your own meeting notes, that Mr. Niven informed Shelter as early as September 21st, 2016, of the city's position that Shelter would lose its contractual rights when the development agreement expires, that the city, or pardon me, that the landowner would be, quote, at the whim of the council following that point?
With respect to zoning regulations that applied to the council, or applied to the property, that's what he was referring to as being at the whim of the council. And contractual rights do not include vested rights that occurred pursuant to the development regulations that were in place at the time of the application.
You don't construe Mr. Niven's statement regarding contractual rights as referring to rights that accrued under the Issaquah Highlands Development Agreement?
I don't construe his statement to be referring to vested rights, particularly because at this point in time, we weren't talking about vested rights. There was no doubt about vested rights. We were talking about future zoning of the property and future regulations that would apply after the development agreement terminated. There was nothing to make anyone think that vested rights were at issue.
Could you please read aloud the third bullet point on page 4, beginning with Patrick questioned?
Patrick questioned what will happen to projects vested under the DA. Keith said that if a project is vested under the DA, it will remain vested for the term of the vesting permit. Lucy pointed out that once zoning changes, the permits do not have to be extended.
Was there anything in this reference or your discussion on this point at that meeting that specifically referred to a permit application as opposed to a permit or approved permit?
Well, vesting always refers to an application.
I would repeat my question. Was there specific references in this discussion to applications?
I don't remember the exact terminology used, but vesting issued permits. Vesting isn't an issue for issued permits. Vesting is an issue for applications.
Could I please have you turn to your meeting notes from October 27th, 2016?
2016, is that what you said? Okay.
This is a meeting between, according to your notes, Gary, Tia, and Keith, and I assume from context that that is Mr. Young, yourself, and Keith Niven.
Yes.
Who initiated this meeting, do you recall?
I don't recall.
Do you please look at the 8th and 9th bullet points on the first page? What was the context of those statements?
I believe this meeting happened just after Mayor Butler had written us an email telling us that he had no interest in the mixed-use project that we had been working on with the community and with the staff, but more with the community at that point. And so this was a follow-up meeting to that, if I'm recalling the dates correctly. And so Keith was explaining some of the factors that he saw as challenges to the timing at which this issue was coming up. He also explained that he did not think that this council was very economically oriented, and cited the example that they had enacted the moratorium without ever considering the financial impacts on the city, and that they were only now coming to think about the impacts. And he described them as coming from privileged backgrounds where they never had to worry about money.
Do you please look at the first hollow bullet point at the top of the page, beginning with Shelter Holdings wants to focus?
You want me to look at it, or what are you asking me?
Yeah, could you please refer to it? I'll ask you a question about that. The reference is that Shelter Holdings wants to focus on residential. Is that an accurate statement of what Shelter's proposal was at that point in time?
Well, that bullet is giving the two reasons that the city does not want to work with us. And so he said one of the reasons was that we wanted to do residential, and the other reason was that the office market might not be there, and that office was really the only thing that the city was interested in. So the fact that we couldn't perform because there was no market support for the one thing that they wanted was one of the bases for not wanting to work with us.
And in the third bullet point, beginning with council believes, indicates, according to these notes, that no one in the Highlands, at least according to the city council, supports any residential on our site, including President Stacy Goodman and UVDC members Jeff Walker and Carl Lay. Is that an accurate statement of our understanding of what was said at this meeting?
Yes, that Keith told us that, yes.
So your understanding as of October 27th of 2016 was that the Issaquah City Council believed that no one in the Issaquah Highlands supported any residential development on your property?
My understanding was that that's what Keith told us that the council believed.
Could you then please turn to your meeting notes from November 10th, 2016?
Okay.
Okay. According to your notes, this meeting involved Mr. Young, yourself, Mary Lou and Mariah, Mary Lou Polly and Mariah Batiste.
Yes.
Who were Mary Lou Polly and Mariah Batiste?
At that time, they were both council members for the city of Issaquah.
Okay. How did you happen to have a meeting with individual council members on November 10th, 2016?
We reached out to them.
You initiated this meeting?
I think probably Mr. Young did.
Do you remember the purpose of doing so?
I think we were wanting to get direct feedback from the council members as to what they were thinking or what their vision was for the long-term planning of our property.
And this was before Mary Lou Pauley became mayor, correct?
Correct.
Could you please read the third bullet point from the bottom of the page, beginning with, on page 1, beginning with, when asked about? Read that aloud, please.
When asked about her thoughts on retail on the property, Mary Lou said staff has never given them any recommendation on that and has really never shown them what the original vision for the property was. But whatever that was, she would need to see that to stick with that. She said staff has not had the time to provide that information to council. She was unsure about retail.
So if I understand this notation correctly, Ms. Pauley, or Councilmember Pauley at the time, didn't indicate any particular opposition or support for any shelter proposal at that time. Is that your understanding as well?
Well, at this point in time, we had received the message from the mayor that the original mixed-use thing that we wanted to do was a no-go. The city wasn't going to support it. They told us to go focus on what was in the development agreement and do that. So that's what we were trying to do. One of the concepts that we floated to council members Pauley and Batiste was to just extend the development agreement as it was with respect to our property to this, I guess to back up again, you have to give more context. The moratorium had been enacted and staff resources were being focused on the work plan and figuring out how to get out of the moratorium. At the same time, there was this need to figure out what zoning would come after the development agreements in Issaquah Highlands and Talus. So our suggestion was just extend it with respect to our property, which is probably the most contentious because it's not developed yet. And we will then focus on the uses that are allowed by the development agreement. That's what we were doing at that point in time. So we didn't have necessarily a specific proposal to put in front of her, and that wasn't the point of that meeting. It was to talk bigger picture. And initially, she had indicated openness to that concept. She thought it made some sense, but she wanted to defer to Director Niven's advice on that.
So you would characterize her position on future retail development on your property or shelter's property as being essentially non-committal or open at that point?
Yeah.
Could you please look at the fifth bullet point from the bottom of the page on page 1 of your November 10th, 2016 notes, beginning with Gary and Tia? Could you please read that bullet point aloud when you have a moment?
I can read it, but I think it needs context to make sense.
Please.
So I think what we were trying to explain to her was as we started to really focus on the uses under the development agreement, which were the commercial and retail uses, we were finding that the end user of the property, whether that be an office developer or an office tenant or retail or medical office, those end users always want to know that when they start spending their resources engaging with you, that you can perform and build whatever it is, or sell for them to build whatever it is that is the plan. With a development agreement with a term that had a process for terminating potentially coming up, and not having any indication from the city as to what that zoning that might replace it at some unknown point in time, there was a lot of uncertainty. And so we were feeling that impact our discussions with the brokerage community and the potential end users. And so that was one of the reasons why it was appealing to us to just extend it as is. Let us keep working this. Give us the tools to make what you are telling us you want happen.
And that the reference then in that bullet point of your notes to the expiration of the development agreement bringing urgency to this issue was informed by what you just said?
Yeah, because I think she was, she meaning Councilmember Pauley, was saying, you know, all of our staff resources are devoted to this moratorium. We really don't have time to undertake anything else. And we were trying to explain to her that there was a time sensitivity because of the potential end of the development agreement. So it wasn't something that could simply wait for a moratorium that was slated to take 18 months to work out of, to be resolved.
In your second bullet point on page 1, beginning with, Gary began by acknowledging issues and timing problems that exist in the city. What was Gary, who I assume is Mr. Young, referring to in his reference to issues and timing problems that exist in the city?
I believe he was probably referring to the same issues that I just described about the moratorium and staff being allocated to the moratorium, and potentially to the issues that Keith had identified in one of the previous meetings minutes that we had looked at.
And in the third bullet point, beginning with Mary Lou started off, do you please read the second sentence of that bullet point?
Staff does not have any ability to take on another large project.
Thank you. That was communicated to you and Mr. Young at the meeting?
That was what I was just explaining, that she was citing the moratorium as a reason for a bandwidth issue for staff.
And bandwidth, as you understood it, I assume, referred to staff availability and resources at that time?
Yes.
Will you please turn to page 2 of your meeting notes? And please read the 6th and 7th bullet points in the middle of the page aloud.
This is what I think already explained, that we suggested extending the DA, at least with respect to our property, may be a win-win, as it would give everyone some time. We could pursue the office, commercial, retail, and staff, and staff would not have to deal with rezoning our portion of the property yet. Mary Lou said she had not heard that idea and seemed to like it. She suggested that we pursue it with Keith. Mariah agreed that it sounded like a reasonable idea.
So at this point in 2016, then Councilmember Pauley was amenable to the proposal that Shelter had put forth regarding extension of the development agreement?
I wouldn't probably call it a proposal because it was just in discussion with her, but yes, she didn't immediately object to it. It was only after she got Director Niven's input that the city responded that they weren't interested in that either.
As of this date, Mary Lou said that she had not heard that idea and seemed to like it, quote, end quote. Your notes indicate that she was actually visibly supportive of that, don't they?
Yes, I mean, she was open to the idea. She hadn't had any input from staff yet, and she didn't immediately have a negative reaction to it. She was open to it.
Could I draw your attention to 3 bullet points below that, beginning with Mary Lou suggested? The entire sentence reads, Mary Lou suggested we meet with other council members. Did you meet with other council members at her suggestion?
We reached out to all the council members. Some of them met with us and some of them did not at various times.
And then could you please read the second bullet point from the bottom of the page, beginning with Gary asked aloud?
Gary asked if they were comfortable disclosing how they/the city feels about shelter and whether they have any concerns. They both agreed they felt good about shelter and that shelter has a good relationship.
Who is they in that sentence?
It would be Mariah and Mary Lou.
Ms. Pauley, at this point, Councilmember Pauley, along with Councilmember Batiste, both agreed that they felt good about shelter and that shelter has a good relationship.
That's what they
An
told
accurate
us.
reflection of your notes at the time?
Yes, that's what they told us.
Could you please then turn to meeting notes from November 14th, 2016?
Yes.
And Mr. Chairman, my co-counsel has just reminded me that we're approximately 1 hour into the proceeding, and I'd be happy to break at this point if you think it'd be appropriate for a restroom break for everyone.
I think that would be appropriate. I appreciate it. Let's
Thank
take
you.
a 10-minute break. Thank you. All right, I'd like to bring the meeting back to order, and Mr. Lell, you may resume your cross-examination.
Thank you, Mr. Chairman. Ms. Heim, could you please turn to your November 14th, 2016 meeting notes?
Yes.
And this, as I understand it, was a meeting between Mr. Niven, Mr. Young, Mr. Mullaney, and yourself.
Yes.
Was this meeting at Issaquah City Hall Northwest?
I don't recall the location, but I would assume that that's probably where we met.
Did you attend this meeting at the city's request, or did you and the shelter team initiate the meeting?
I don't know.
Could you please turn to the third bullet point on page 1 of your meeting notes and read that bullet point aloud for me?
This bullet point says, he explained that when we met with Mariah and Mary Lou, they expressed a real concern that the staff's workload due to the moratorium was such that they cannot deal with anything with respect to our property until after the moratorium work is done. However, they were open to the idea of extending the DA with respect to our property to allow us the opportunity to pursue the commercial users that the city wants, while also giving the city time to breathe without having to focus on planning for this property.
If I understand this portion of your meeting notes, Ms. Heim, this was a reiteration by the city that staff's current workload at that time was extraordinarily high. Is that correct?
No, that's not correct. Actually, this bullet is, the he in this bullet is Gary. And so this was Gary explaining the meeting that we had with council members Polly and Batiste. So he was explaining that conversation that we just had gone through just prior to our break. And we were getting then Keith's reaction to that.
But nothing in that status had changed in the interim period between the previous meeting and this meeting. Is that correct? With relation to staff's workload at the time?
I have no way of knowing that.
Well, there's a statement in your meeting notes from November 14th where Mr. Young is stating that. Did anyone correct that statement from him?
He was explaining what Mary Lou Polly had told us at the previous meeting.
Did anyone correct that statement by Mr. Young at that time?
I'm not sure. He was explaining something that had happened, and so what would need correcting?
Anything happen to your knowledge with respect to the staffing at the city, in the city's Development Services Department, that would have evolved or changed since the previous meeting?
Are you asking me if there were staff changes between November 10th and November 14th?
Were you aware of anything that would change the staff workload concern that was expressed at the prior meeting?
I'm still not following what you're asking me.
That's apparent. I'll move on to the next question.
Okay.
Can you please turn to the second page of your meeting notes from that meeting? In the third bullet point, beginning with Patrick asked about.
So it says, Patrick asked about whether Keith had given any more thought to how they would address mitigation paid in the zoning option. Keith said some of it's easy and other pieces are hard, but his initial thoughts are as follows. He encouraged us to put together a first proposal for the city's consideration and said the city's not trying to gouge us.
So Mr. Niven said that the city is not trying to gouge you as shelter. Is that correct?
Yes, that's what he told us at that meeting.
And Mr. Niven, according to these notes, encouraged shelter to put together a first proposal for the city's consideration regarding mitigation?
Yes, and we did that.
The enumeration of potential mitigation items that follows in that third solid bullet point and continuing through the 4 hollow bullet points regarding water charges, governmental service impact fees, fire, and traffic. Is this the first time that these mitigation measures, or any credit for them, was discussed between the city and Shelter?
I don't think so. I think in one of the earlier meetings, there was reference to traffic mitigation being discussed. But following up on this, we did submit the first proposal that he referenced, or that was referenced in the notes, and it was requested by Keith, but we never got any formal response from the city.
But Mr. Niven at this meeting again reiterated or expressed his encouragement for Shelter to provide a proposal regarding mitigation and any credit for that, correct?
Yes, and then when we provided it, the city never responded to it.
And this is after Mr. Niven's comment regarding the, quote, evaporation, end quote, of mitigation under the development agreement that occurred on, I believe, the September 21st meeting notes.
Yeah, I think you're identifying one of the things that happened throughout this process was that the city would take one position and then take another position and change their mind about how things were going to be treated.
Could you please turn to the next page of your meeting notes and the first bullet point beginning with Patrick asked how? And read both the solid bullet point and the hollow bullet point underneath it for the record, please.
Sorry, which one did you want me to read?
The first bullet point at the top of the next page beginning with Patrick asked how.
Patrick asked how and when the vesting portion of the zoning option could be negotiated. Keith suggested that we make a proposal and agreed that sooner is better than later. He encouraged use, I think that means it's supposed to be us, to look at the mitigation fee appendix to the development agreement. Now, again, this one needs some
Please just
context.
continue reading the hollow bullet point. I'll ask you if I want some context after that. Thank you.
Okay, I just have to say that the vesting reference here is not, it's again vesting under the development agreement.
Again, if you could please just read the text that I've asked you to read. I'll come circle back with context if that's appropriate.
Okay, for the record, I don't think that this will accurately answer anything, reading it without the context of what we're
Again, if you
talking
could
about.
please just read the text that I've asked you to read, to the extent that your own counsel has follow-up questions and you'd like to express context through that redirect examination, that's your prerogative, but I'd ask you to read the specific test that I've asked.
Patrick questioned how this would be documented, and Keith suggested a mitigation certificate of some kind would be used so that it could ride with the property.
Thank you. Are you familiar and have you read the Issaquah Highlands Development Agreement at issue in this proceeding?
Have I read the Issaquah Highlands Development Agreement?
Yes.
Yes.
To your knowledge, is there a reference in the Issaquah Highlands Development Agreement to a mitigation certificate?
Not that I recall.
To your knowledge, is there a reference to a mitigation certificate in the Issaquah Municipal Code?
I don't know.
To your knowledge, is there a reference to a mitigation certificate under Revised Code of Washington?
I don't know.
So Mr. Niven was suggesting in his own right at this meeting an outside-the-box approach to facilitate some type of credit or offset protection for Shelter. Is that correct?
He was discussing it. It didn't ever have an opportunity to move beyond just discussion.
Your notes, Ms. Heim, indicate that Mr. Niven encouraged Shelter to look at the mitigation fee appendix to the development agreement, and that Keith suggested a mitigation certificate of some kind that could be used. That seems like an affirmative suggestion, wouldn't you agree?
A suggestion that when we did the things that he asked, he never responded to.
Could you please turn to your meeting notes from March 21st, 2017?
Okay?
Do you recall who called this meeting or who initiated this meeting?
Well, this was a collaboration meeting for the binding site plan / plat application. So when we met with Director Niven initially to talk about doing a binding site plan, we were informed that the collaboration meeting should be the first step. So then in response to that, we asked for a collaboration meeting.
Okay, thank you. And it looks like the attendees for this meeting were Mr. Niven, Ms. Sloman, Dan Irvin, Gary Young, Patrick Mullaney, Mark Velde, Dave Caton, and Tia Heim. Is that correct?
Yes.
Could you please remind me who Kurt Seaman is?
I don't know for sure, but I think he was a transportation person for the city.
And Mr. Irvin?
He was the city's, I think, engineering consultant.
And Mark Velde?
He's our engineer.
Thank you.
He's with KPFF.
Thank you. On page 1 in the second bullet point, could you please read that text beginning with "city indicated"?
City indicated that they would support a plat to create the lots, and that this would be the simplest path. Keith acknowledged that a plat would vest for 5 years, and then 5 years from the final plat date, and added that we could get vested for an additional 3 years by filing a site development plan after the final plat.
Thank you. Are you aware, Ms. Heim, of anything in the Issaquah Highlands Development Agreement that refers to some type of a 5-year vesting period for final plats?
Let me think about this for a second. I can't recall if there's anything in the development agreement, but under state law, a plat vests for 5 years.
Thank you. And so I'm clear in your understanding, the 5-year plat vesting that you referred to under state law, is that, to your knowledge, contained in RCW 58-17-170, subsection 2A?
I don't have that in front of me.
I've just handed you a copy of that statute. I'm sorry, it's a printout from the RCW. I can just look at what you guys got. Thank you.
So what was your question again?
Is your understanding that the 5-year period referred to by Mr. Niven for final plats, is that the same 5-year period that's contained in that RCW provision that I've just provided you?
I don't know what he was referring to in that meeting. I just know that that's what he told us.
Okay. And I'll rewind then. Are you aware again of any provision in the Issaquah Highlands Development Agreement that would set forth a 5-year period for final plat vesting?
I don't know without reviewing the agreement for that specifically.
Are you aware of anything in the Issaquah Municipal Code that would establish that sort of a 5-year vesting provision for final plats?
I've never done the research on that.
Thank you. Are you aware of anything in the Issaquah Highlands Development Agreement that would establish the quote, additional 3-year period, end quote, that was referenced by Mr. Niven for a site development permit?
I assumed he was referring to the fact that I believe site development permits are valid for 3 years.
And do you know where the authority for that requirement would be?
I don't.
For the record, I'm handing you the hearing room copy of the Issaquah Municipal Code, and specifically referring your attention to IMC 1804-220, subsection D1. Do you see that text, Ms. Heim? Mm-hmm. I'm sorry I didn't bring a copy for council, but you're welcome to look at the code book. Do you agree that that provision contains a 3-year effective period for approved permits?
I can't tell what kind of permit we're talking about here, but it says final decisions approving applications shall be valid for 3 years from the date of application approval, as specified in the notice of decision, except where a longer time period is adopted per this chapter.
Thank you. Ms. Heim, based on what I've showed you, is it your understanding that Mr. Niven's references to a 5-year period for final plats and a 3-year period for site development permits, as referenced in your March 21st, 2017 notes, were in reference to an approved land use decision? Or did Mr. Niven give any indication that he was referring to an application for a land use decision?
I'm not sure I understand that question.
The second bullet point of your March 21st, 2017 meeting notes that I believe that you've just referenced, is there anything in that bullet point that refers to an application as opposed to an approved permit?
I think that this reference to the site development, filing a site development plan is reference to a permit application.
Did Mr. Niven say that during the meeting?
I don't have his exact quote, but he explained to us that the theory for vesting that we should follow was we were working on the plat application at this time. That's what they were telling us to do, is do the plat application, not the binding site plan, that we would have 5 years from the time the permit was issued to file our final plat and record that, and that we would have 5 years from then to file SDP, which would then give us 3 years from that approval.
Can you please look at the 4th bullet point in your March 21st, 2017 meeting notes and read that for me, please?
Keith added that his belief is that we vest to land use regulations, but not to process.
Okay.
So he thinks that if they later change the process.
I'm sorry, I just wanted you to read the text.
That was the text.
There's just the first sentence, excuse me.
Oh.
Did he elaborate on that statement, the one concerning process, at this meeting?
I think the next sentence addresses it, but
Beyond that?
yeah, at various times, including at this meeting, he talked about vesting that a vested application would vest to regulations or standards, but not necessarily process. However, that's not how the city has been handling vested applications.
If I could please have you turn to your meeting notes from May 31st, 2017. I'm sorry, pardon me, your meeting notes for September 7th, 2017.
Okay,
These are apparently handwritten notes
yes,
by you.
yes.
And do you recall if you prepared these notes contemporaneously with the meeting or afterward?
Yes, these would have been contemporaneous with the meeting.
Who attended this meeting?
I can't tell for sure from this meeting, but I do recall that this was the meeting where we went in to meet with Keith, and this was the meeting at which we told him that we were planning to come in with site development permit applications. So I know that at least Keith and myself were there, and I'm not sure if it would have either been Eric or Gary with me from our team.
Just to clarify, you informed Ms. Niven at this September 7th, 2017 meeting of Shelter's intent to come in for site development permit applications?
Yeah, at that time, we knew that we were coming in with the retail and the medical office, and we didn't know for sure what the other ones would be.
Thank you. Could you please turn to page 2 of your notes? There's a reference to Patrick /Jim, and then a dash that proceeds with Jim says nothing vested, DA expires, and all apps are unvested? Is that an accurate recital of that text?
Yes, that's what it says.
Could you explain to me what that was intended to mean? Is Patrick Mullaney?
Patrick would be Patrick Mullaney, and I think that bullet or that text is referring to the fact that Keith was saying that Jim, meaning Jim Haney, was saying that nothing is vested, the DA expires, and all applications are unvested.
Thank you. And just for the record, Jim Haney would be the Issaquah city attorney, correct? At that time?
Yes, I believe so.
And it is your recollection that Keith explained this, and you were essentially paraphrasing Mr. Niven? Is that accurate?
My understanding is that Keith was telling us that Jim was taking these positions and that he told us he didn't agree with them, and he was asking us to have Patrick speak with Jim.
Okay. So is that statement, or that last statement, reflected somewhere in your notes?
No, that's my recollection of the meeting.
Thank you. But at least from what's written in your notes, Shelter was on notice as of September of 2017 that the Issaquah city attorney's position, at least with respect to vesting, was that, quote, nothing vested when the development agreement expires, and that all applications are unvested.
There were many positions articulated. That was one of them. They also took the position that issued permits would disappear and evaporate, and that was also categorized as Jim's advice. So there were lots of different versions of what we were told was Jim's advice, and we were told to go speak with him. Just because somebody told us that that may be a position of the city doesn't mean that That's what the development agreement says.
My question, I just wanted to clarify that this was what was explained to you or expressed to you at that September 2017 meeting, as your notes apparently indicate. Is that correct?
It was said to us and explained that the Development Services Director did not agree with it.
Okay. And does the Development Services Director's alleged disagreement with the city attorney show up in your notes here?
No, but you also see right below it where the notes say that the city hasn't asked for the city attorney's opinion. So again, we were getting conflicting messages from the staff. So he's saying, Jim's saying this, Patrick needs to talk to him. We haven't actually asked him yet, and we're going to do that next week.
So your notes reflect the fact that the city attorney had opined on this issue, but the city hadn't asked for the city attorney's advice?
Correct.
Thank you. Could you please scroll down to near the bottom of the second page of your notes from this meeting, immediately above and to the right of a heading entitled Step 1, there is a reference that states, quote, "Lucy wants vesting," end quote. Do you recall the context and purpose of that reference and who said it and what the reason for that was?
Yeah, I believe that was a reference to the fact that Lucy wanted to include vesting language into the replacement regulations, which were in draft form at that point.
And Lucy was Ms. Sloman?
Yes.
Did Ms. Sloman, as part of this meeting, express her desire for a particular substantive content of those vesting provisions in the replacement regulations at this meeting?
I honestly can't tell from the notes if she was at this meeting. I know at this point in time, the city staff, meaning Ms. Sloman and Mr. Niven's position was that the vesting language that should be included in the replacement regulations should reflect what the city was doing with respect to vesting throughout the city, which was to acknowledge that vesting occurs at preliminary land use, complete preliminary land use application. So that would have been the position that she would have articulated at this point in time.
Okay, and you don't have a direct recollection of that?
I can't tell you if it was at this meeting or a week before or a week after, but at this point in time, that's what the city's position was, and you can see that when the initial drafts of the replacement regulations came out, that was what was included.
So if I understand your testimony correctly, Ms. Sloman was in favor of generous, broad vesting protection in the replacement regulations. I'll withdraw the question. Could you please explain again, Ms. Heim, what you felt based on Ms. Sloman's comments were to you that Ms. Sloman wanted to see in the replacement regulations in terms of vesting?
I think that what staff initially proposed and wanted to see at that point in time, meaning in the fall of 2017, in the replacement regulations, was vesting language that they felt complied with Washington state vesting law, which was to acknowledge that the vesting of applications, of site development permit applications, should happen at the preliminary land use application stage. And that was because both the site development permit and the preliminary land use permit application were required steps in the building permit process, and the staff referred to them as linked permits.
And when you say that staff had supported vesting language of that type for the replacement regulations, are you referring to both Ms. Sloman and Mr. Niven?
I'm assuming yes, because the memos and things that the presentations were by one or both of them.
To your understanding, both Mr. Niven and Ms. Sloman favored the type of vesting language that you just described?
Initially, in the fall of 2017, yes.
As of this point?
Yes.
We're referring to in September of 2017 at the time of the notes for which this meeting were taken?
Yes, that's what they told us, yes.
Could you please turn to your meeting notes from November 28th of 2017, this is apparently from the PPC hearing on September 28th of that year. Is that correct?
Sorry, I'm still getting there.
And in case I inadvertently said November, I'm referring to September 28th and your notes from that meeting.
Oh. Okay, September 28th.
Yes.
PPC.
Yes. For the record, did you attend this meeting of the PPC?
I did. This was actually the hearing, the initial hearing on the replacement regulations.
And the PPC acronym is in reference to the city's Planning Policy Commission, correct?
Correct.
In the fourth hollow bullet point, under the first solid bullet point, in reference to statements that were apparently made by Ms. Sloman, it stated that Ms. Sloman noted that it won't apply to Polygon where they have a vested land use permit, but they meet it anyway. Could you tell me what that statement is in reference to?
That statement is related to the parks requirement that they were talking about in the replacement regulations, and it was referencing that for Polygon's vested permits, they wouldn't have to meet the new requirements because they were vested. So Polygon had certain permits that were already vested at that date.
Do you recall what the status of Polygon's permit, I'm looking at the word permit as being singular in this reference in your notes. Do you know what the status of Polygon's permit was in the city's application process at that time?
They have multiple projects, and so I could probably figure it out from looking at the exhibit that we looked at last night, if you want me to do that.
If you could, I think that would be helpful. And I'm happy to take a break if you think that would be more than a few minutes.
It just depends. Jackie, can you, the demonstrative that we had last night? Okay. This one?
It's not in color, but it should.
Okay, yeah, that will work.
Use me. Bless.
So I think that it would have referred to likely the Polygon Westridge North single-family plat application, because that plat application was submitted in July of 2017 and was deemed complete in July of 2017. I suppose it also could have referred to an issued permit, but I think because, I guess it doesn't, my notes don't distinguish whether they're talking about an application or a permit.
Okay. Thank
But-
you. I appreciate that clarification. In the next hollow bullet point, I believe that you're paraphrasing Ms. Ms. Sloman here. You say, in response to question, she, apparently Ms. Sloman, pointed out that Polygon's Tract D is not vested and will be subject to the new regulations. Do you know what that reference meant? And what is Polygon's Tract D?
It would have been one of Polygon's other parcels that did not yet have an application submitted.
As of September 28th, 2017.
Correct.
Was there much discussion in the open session at this November 28th PPC hearing regarding specific project permit applications and the status of them in the Issaquah Highlands?
If you wanted me to answer a question on specific content of the meeting, it'd be helpful to have the presentation in front of me.
Sure, I'll come back to that. The next bullet point, the solid bullet point beginning with Lucy talked, could you please read that bullet point in its entirety out loud?
Lucy talked about vesting and said it was complicated and talking with the city attorney. Certain permits are vested by state regulations, but that the city gets to make a policy decision with respect to all other permits.
So this was the expressed position of city staff as of September 28th, 2017, in an open public meeting, correct?
There was no vesting language yet provided in the replacement regulations that were subject of the hearing, and so they had a placeholder in there and said it was coming. So in her presentation, this is what Lucy expressed.
Throughout the remainder of that September 28th, 2007 meeting, did Ms. Sloman make any additional comments publicly that would contradict that statement regarding certain permits are vested by state regulations, that the city gets to make a policy decision with respect to all other permits?
Not that I recall, but there wasn't much discussion on vesting at this point since there was no vesting language proposed as part of the replacement regulations.
Do you recall approximately how many people attended that public hearing?
I don't.
I then have you turn to your meeting notes from October 12th of 2017. I'm sorry, the October 2nd, pardon me. This is also a series of handwritten notes, as far as I can tell, and the indication at the top of the page on page 1 would suggest that it was a meeting with Keith. So this was a meeting between yourself and Mr. Niven?
It would have included either Gary Young or Eric Evans also. I never met with Mr. Niven by myself.
Okay, thank you. And could you please turn to page 2? There is an underlined handwritten heading entitled, I believe, Big Topics. Do you see that?
Yes.
Okay. And I believe connected with that, a reference to min FAR, which I assume is minimum FAR. Does that comport with your recollection?
Yes, because the minimum FAR was proposed to be added to the replacement regulations just before that hearing on September of 2017.
And immediately below that big topics heading, there is a statement, if I'm reading this correctly, that reads, Mayor supports FAR in IH and Talus. Is that an accurate reading of your handwritten notes?
Yes,
Okay. And the mayor at this point would have been Mayor Fred Butler, correct?
correct.
Mayor Mary Lou Pauley, the city's current mayor, had not yet taken office or been elected.
Correct.
Was this the first that you had heard that Mayor Butler supported a minimum floor area ratio in the Issaquah, Highlands, and Talus areas?
I believe so, because the minimum FAR came as a complete shock to us. We had been having ongoing discussions with the city about the replacement regulations, and nothing was included with respect to minimum or maximum FARs. And then right after we introduced the fact that we were coming in with our retail proposal and our medical office building, the staff introduced the minimum FAR concept, which would undermine both of those projects. So this would have been one of our first discussions with staff regarding the minimum FAR, as we were totally blindsided by it.
Do you recall, was the mayor at this meeting, or was this reference to the mayor supporting a minimum FAR information that was conveyed to you by Mr. Niven or other staff members?
No, the mayor was not at the meeting, so this would have been something that Mr. Niven was telling us.
And if I could refer your attention back to the previous page of your October 2nd minutes, there is a reference on the first page in about mid-page under the heading Min FAR that reads, I believe, admin won't back off FAR, quote unquote. Is that an accurate reading of your handwritten notes?
Yes.
What did that mean?
The administration won't back off of requiring a minimum FAR.
Who was the administration that you were referring to at that time? Was that Mr. Fred Butler, the mayor, or was that some subordinate official in the city's bureaucracy?
I understood it to be Mr. Niven and the mayor.
Going back to the second page of your meeting notes, under the heading underlined vesting, there is text that reads, and I'm struggling a little bit with the handwriting, but please correct me if I'm wrong, quote, code will identify SDP as vesting permit, pre-app application vests you, plat SDP ASP will address vesting in code. Is that an accurate reading of your handwritten notes?
That is accurate, and I can give you some context if you'd like.
Please, thank you.
So this was Mr. Niven explaining to us that the code language was going to, the vesting language that they were going to be inserting into the replacement regulations was going to identify that site development permits were a vesting permit, and that preliminary land use applications vest for purposes of city code. And so then the list underneath of plat, SDP, ASDP, that was just a note that they would all be addressed in the code. So they had, this was articulating the position of what was going to be proposed by the staff and the administration as far as vesting language in the replacement regulations.
If I'm understanding that statement in conjunction with your prior testimony, the same time staff were proposing a minimum FAR, they were also proposing vesting language for purposes of the replacement regulations that would vest SDPs, pre-applications, plats, perhaps other?
Yes.
Thank you. Could you please look at the handwritten heading beginning with the word M, and I believe it is mitigation, but I will defer to you on that because this is your writing. Do you see that about 2/3 of the way down the page on page 2?
Yes.
Is that word mitigation?
Yes, I believe so.
And the text that immediately follows that is, quote, Jim Brightline expires, hasn't waiver, end quote? Is that accurate?
I think that looks right.
Could you please describe what this was intended to mean?
This is what I was talking about earlier, where Mr. Niven would explain to us that he thought the city attorney was taking one position and he didn't agree with it. So with respect to mitigation, and this is separate from the vesting issue, but just mitigation provided under the development agreement and what happens to it after termination. So Mr. Niven was telling us that the city attorney was still taking the same position.
And again, Jim in that context is Jim Haney, the city attorney.
Correct.
Could you please again, and I'm sorry if I missed this, explain the reference to waiver in that statement?
I think that means, I think it actually should mean wavered, like he has not wavered in his position. But again, we never, despite all the attempts we made through our attorney to contact the city attorney, we never got direct feedback from him as to what the actual position was until much later.
Thank you. Could you please turn to your meeting notes from October 12th, 2017? This is also a handwritten document, and apart from the date reference on the top of the single page that's provided here, there's a basic reference to meeting with Keith Niven. Do you see that text?
Yes.
Were there other attendees at this meeting?
I can't tell from the notes, but I know, like I said before, that likely Gary Young or otherwise Eric Evans would have attended with me.
Could you look about 2/3 of the way down the page under the handwritten heading, I believe this is correct, tomorrow packet, and the reference to ask Lucy for code potentially narrow gap by vesting language to be inserted. City attorney working on it now. Was that an accurate reading of your notes?
I think so.
Please explain what that was intended to mean.
There was some sort of packet coming out for a public meeting, and that I was supposed to ask Lucy for the draft code. I'm not sure what potentially narrow gap means, but it also references that vesting language was to be inserted in the code and that the city attorney was reviewing the vesting language that ultimately got inserted into the code in October of 2017.
So that vesting language was ultimately inserted into the code as these meeting minutes indicated would happen. That's correct?
At some point in October, I don't have the exact date in front of me, there was a draft of the replacement regulations that came out that included vesting language, which was as described by Keith at the previous meeting, and it acknowledged the vesting of land use applications.
And that was a vesting approach that was supported by the then administration? as far as you were aware?
I would assume because it was being recommended to Land and Shore and to council, and it had been reviewed by the city attorney.
Did you publicly express your support for that vesting language?
At some point we did, yes.
Express your support.
It would have either been in comments at public meeting or in letters.
Letters into the public hearing record or letters to staff?
Well, I mean, there may be emails with staff, but for sure in the public record. At one point, Mr. Niven asked us not to, or suggested, I should say, that we not bring up vesting because he didn't want to call attention to it necessarily if the council or Land and Shore weren't raising it on their own. And then later in the process, he asked us to support the language, and we did.
If I understood your testimony right then, Mr. Niven was suggesting that you not publicly acknowledge or support the proposed vesting language because he was attempting to ensure that it passed or to not draw attention to it in the eyes of the council or Land and Shore Committee? Was that the purpose, as you understood it?
As I understood it initially, he just advised us that if they were not bringing it up, then we should not bring it up. It was in what was being proposed. Later in the process, he asked us to support it, which we did.
Did you interpret Mr. Niven's comments in that respect as essentially favoring your proposal, your position on the vesting language?
I mean, we weren't having a position. The city was taking a position.
But it was a position that you were publicly supporting, I believe you just testified. You indicated.
That later we publicly supported it, yes.
And that was consistent with what staff was also supporting. So
Yes, I mean, the replacement regulations, it was a really long document, so, I mean, there were lots of provisions that we never said, oh, I really like section 1819B, blah, blah, blah.
I'm sorry, Shelter never expressed a specific support for,
Every provision in the replacement regulations, no.
but it did express support for the vesting provision that had been proposed by city staff.
At some point we did, yes.
Mr. Chairman, this might also be a good time for a break. We're essentially another hour in, but I'm happy to keep going if that's your preference.
Want a break? Okay, I appreciate that. Let's take a 10-minute break. Thank you.
Before we go on break, I'm just curious if you have kind of a rough idea of how much longer you might be with your cross tonight, or do you think you'll wrap up, or?
I think we're probably going to be going through the evening, and I apologize, Mr. Chairman. I believe that I may have been a little optimistic in my original estimate on that. So I fully expect that our cross-examination will consume the rest of tonight's proceeding.
We probably didn't have a different expectation than that, so understanding legal time constraints, so I appreciate it. Let's take a 10-minute break, and we'll be back. Okay, I'd like to call the meeting back to order, and Mr. Lell, would you please continue your cross-examination?
Thank you, Mr. Chairman. Can you please turn, Ms. Heim, to your October 3rd, 2017 meeting notes?
Yes.
This, again, is a handwritten series of notes, and it's only titled with the date, Collaboration Meeting Retail, and it appears that the attendees are MG2, APFF, yourself, Ms. Sloman, and Jean, who I assume is Jean Lynn, is that correct?
Correct.
And who is MG2?
MG2 is our architect and consultant on the retail proposal, and KPFF is our engineer.
Thank you. What was the purpose of this meeting?
This was the collaboration meeting for the retail SDP.
And was there any discussion regarding vesting at this meeting?
I don't see any reference to it in the notes.
Was there any discussion at this meeting, to your recollection, of the replacement regulations in whatever form they happened to be at that point?
I don't see any reference to replacement regulations.
Okay. Did staff who attended this meeting, which apparently was Lucy Sloman and Jean Lynn, express during the course of this meeting any opposition to the concept of retail development on that project site?
I don't think so. We weren't really talking about the application at that level. We were talking about the actual proposal.
Okay, so just to clarify, to your recollection, and as your notes may indicate, there was no expression by the staff members present at that meeting regarding any opposition to retail development on your property?
No, I think staff acknowledged that it was a permitted use on the property.
They did. They acknowledged that at this meeting?
Well, yeah, I mean, we're sitting there talking about the application, so they acknowledged that the application was going to look like this, and they gave feedback specifically on certain aspects that are noted in the notes, but retail is permitted under the development agreement. The development agreement regulations are what apply. That's what we were talking about at the meeting.
Thank you. Could you please scroll down to near the end of the first page? The reference to Lucy, make it a good neighbor to residential. Something beginning with the word S, start to screen property. Am I reading that accurately?
I think it says, Lucy, make it a good neighbor to the residential, and then it says, Steve, start to screen parking. So that's a reference to one of the comments that we got on I think all of our SDPs was that we needed to make the proposal a good neighbor specifically to the polygon properties that were going to be developed that were closest in proximity to us. And so one of the ways that you do that is through screening your parking and providing pedestrian connections and that kind of thing.
Okay, and that was the reference to good neighbor. That was what that was intended to mean, the screening, in your understanding?
Well, I don't think it's just screening, but that comment was related to how you cite uses next to each other.
Thank you. Could you please turn to the next page of your notes? About 3/4 of the way down the page, the handwritten statement, and I believe I'm reading this correctly, include a detail of how to address residential, then don't have to write it. Am I reading that statement accurately?
Yes, I think that's what it says.
What was that intended to mean?
I think that's a reference to the same thing we were just talking about, just how to address the interaction with residential.
At the very top of the page, there's a statement that I believe reads, Lucy, lessons learned from GRP? Is that correct?
Yes, so that's lessons learned from Grand Ridge Plaza, which is the shopping center across the street from our proposed retail development.
Thank you. And could you please turn to your October 24th, 2017 meeting notes?
Yes.
This is entitled Storage-Lot 9, and again dated October 24th, 2017. I did not glean a reference of who the attendees might be except for a few scattered names on the following pages. Do you recall who would have attended this meeting?
I know that someone from Jackson, Maine Architecture would have attended this. And it would have, again, been Jean and Lucy from the city. It looks like Doug Schlepp also attended on behalf of the city. I can't tell for sure from this. I'd have to look at my calendar or something to figure out what other consultants might have attended.
Okay. What was the purpose of this meeting, if you recall?
Let me think about this. I don't know whether this is the collaborative meeting or the pre-app meeting for the storage proposal, but it's one of the two.
Okay. At the bottom of page 1 of your notes, there's a reference to GR shares B\W all blocks plus some word beginning with C could do same. Am I reading that accurately?
I think it says GR shares between all blocks and we could do the same. So that's, again, a reference to Grand Ridge Plaza and their parking. They share between blocks and they suggested that we could do the same because we were talking about the parking issue with respect to the storage, that the code required way more parking spaces than anyone thought were necessary.
Thank you. Could you please turn to the last page, or I'm sorry, the last page of those meeting notes. There is a reference in your handwriting that I believe reads, quote, "At end of pre-app process, city gives letters of correction or all submittal, particularly requirements for submittal." Am I reading that correctly?
I think it says, at the end of pre-app process, city gives letter of, and then it says above comments and below corrections, additional submittal, particular requirements for submittal.
And I'm sorry, could you elaborate on what that was intended to address?
So I think this is the direction that we were getting from city staff about what would happen at the end of the pre-app process, that we would get a comment or correction letter that might have additional submittal requirements.
And did Shelter receive additional comment letters based on that concept?
Are you asking specifically about the storage?
Yeah, yes.
Yes, we would have received a pre-app comment letter at some point.
Was that letter in evidence already?
Yes, I believe it is. I believe would have been part of that application or resubmittal.
Thank you. Immediately below that reference in your meeting notes, there's a reference that reads, to the best of my ability, quote, "Vesting can't answer. Lucy pointed out to Stacy today, council may disagree that LU permits should vest." Is LU permits a reference to land use permits?
Yes.
Is that an accurate reading of your notes here?
Yes, I think that's what they say.
Okay. In reference to the vesting can't answer, what question was asked that could not be answered?
I believe that one of our consultants asked about when a permit application vests, and Lucy's response was that she can't answer, but then she went on to explain that she had advised Stacy Goodman that day that council may disagree and decide that land use permits should not vest, even though they were currently vesting permits in the city.
Was there further discussion about the vesting issue at this meeting beyond what your notes indicate?
I can't recall.
But just to clarify, Ms. Sloman could not provide a definitive answer to the question of whether your application for the storage building would vest, is that correct?
Yes, I think in the context of the larger discussions that we were having with various people and bodies at the city, there was this idea that often was expressed by Ms. Sloman that whether to continue to recognize the vested status of an application was a policy determination that the council could make. Every time that was raised, we objected to it and said that's not legal, that's not consistent with Washington state law. I don't think that in the context of this meeting there was a deeper discussion, because it was not specifically on that topic. It was on, this was I think the collaboration meeting for the storage application.
If I understood your testimony, Ms. Sloman did reiterate her previous position during this meeting that the council may disagree that land use permits should vest, correct?
Yes, that was her position.
And that was in reference to the pending adoption of the replacement regulations?
Yes, it's sort of confusing because they're talking about a regulation that's not yet adopted and suggesting that it could retroactively apply to remove the vested status, which is a concept that doesn't make a lot of sense and that's not consistent with Washington state law.
And then immediately below this vesting reference in your notes, there is a statement that reads, quote, "Pre-app I believe that's required, per Lucy, parentheses, might be called something else in DA," end quote. Is that an accurate reading?
Yes.
What was that statement in reference to?
Well, we were, again, asking to move forward without a pre-app, and Lucy was again telling us that the pre-application process and meeting was required. And when I pointed out that it wasn't required in the development agreement, she said, well, maybe it's called something else.
Did you respond back to her after she indicated that the pre-app might be called something else in the development agreement, or did the conversation essentially terminate at that point?
I don't remember the details of the conversation. There's email correspondence that goes back and forth around that same time that I believe is already in the record that details that.
Thank you. Could you please turn to your October 26, 2017 notes? This also is a series of handwritten notes, and I could not see any specific names in this document except for a scattered reference to Lucy, Ellis, and Jean. I'm assuming that Lucy refers to Ms. Sloman, is that correct?
Lucy refers to Ms. Sloman. Jean would refer to Jean Lynn. There's a reference to Doug, which would be Doug Schlepp. Ellis is not a person, it's a street.
Oh, thank you. Was there any discussion of vesting in this meeting?
I don't see any reference to it in the notes.
What was the purpose of this meeting?
It was the collaborative meeting for the Block C office or commercial fitness proposal or office fitness proposal.
And at the very top of the first page, there's a reference to asked if Block C retail can proceed with retail, quote, end quote. Is that an accurate reading?
Yes.
What is that intended to mean?
Well, Block C is the block that's on the corner of 9th and Discovery. And so there's 2 lots proposed for that block. The northernmost lot is actually part of the retail SDP application. And then the southern portion of the block, of Block C, was the commercial fitness proposal. So we were just confirming that the city was on board with that and didn't want us to show the retail that's in Block C with this application, and they confirmed that that was fine.
Thank you. Could you please turn to your November 6, 2017 meeting notes?
Yes.
And this is apparently an email sent from you primarily to Derek Strait and Gary Young and Patrick Mullaney with a CC to Eric Evans and Natalie Quick Consulting. Is that correct?
Yes.
Who attended the November 6, 2017 meeting?
I believe it was just Gary Young and Keith Niven and me.
Thank you. Could you please read aloud the 7th bullet point on page 1 of your email?
He had various ideas about how to manipulate the proposed replacement regulations so that they might work for a retail proposal. One of which was getting the surface parking approved as an interim use like Swedish, which has many conditions and a 5-year term, with a 5-year extension if they meet certain requirements, like master planning, building permit for 100,000 square feet. But ultimately, it can't stay for more than 10 years. He called Lucy to his office to explain this. I do not see this as a realistic solution.
Is the he referenced in this bullet point Keith Niven?
Yes.
What does it mean to manipulate the proposed replacement regulations in the way that Mr. Niven was referencing?
So he was talking about doing things like, well, you can meet the FAR, just make your lot really tiny and so that the building covers the whole thing and then that will work. And then, yeah, you can't do surface parking, but we could maybe let you do it in an interim manner where you can have it, but only for a little while. And then when that term runs out, you're going to have to go build a parking structure or something. It was a lot of ideas that, to me, he wasn't all the way familiar with what was being proposed in the replacement regulations because there were aspects of it that clearly didn't work. And it just wasn't a very realistic solution given the regulatory framework that we would be working within.
And the regulatory framework that you would be working within is the replacement regulations, correct?
Yeah, in that context, that's what we were talking about.
That had not yet been adopted at that point, correct?
Correct, with the proposed replacement regulations.
And Mr. Niven, if I understand the context of your notes and testimony, was essentially brainstorming about ideas through which some proposal for shelter might work on that property? Is that?
I think he was
correct?
trying to counter the things that we had been saying publicly about the fact that the replacement regulations don't allow retail, because the city staff had been saying that we were not right about that we actually could build retail, that we were just, I don't know, choosing not to, or saying that it would be too hard when it actually was doable. So this was sort of further discussion on a point that probably came up in the context of more public discussions.
In the hollow bullet point, 1 or 2 lines down from what you just read, there is a reference to, quote, he blames PPC and mayor's office from being unwilling to move on this, end quote. What is that in reference to?
Oh, this is in reference to the proposed minimum FAR of 1. So he was trying to say that it was the mayor and the PPC that that was unwilling. And at this meeting, he was encouraging us to come back with a proposal that spread various FARs out over the site, and he said that our proposal needed to average an FAR of 1, because really what he saw the FAR as doing was guaranteeing a certain amount of total development. And so in the earlier public meetings, he had explained that the way he came up with the proposed FAR of 1 was he just looked at the total entitlement that wasn't built that we had allocated and divided it in half and then spread it across our property. And so that came back with an FAR of 1 to achieve that. So he asked us to go back. He's like, you can put it how you want it across the lots, but it needs to average one so that I can still say the city's still guaranteed or going to get that minimum amount of development. So in this meeting, this is, I think, where he's asking us to do that, and he's blaming the mayor's office and the PPC for sticking to that FAR of 1 that he had proposed.
And just to clarify, as of November 6th, 2017, when this meeting occurred, the mayor would have still been former Mayor Fred Butler, correct?
I believe so.
Thank you.
Although the election would have been, I mean, Mayor Polly would have been probably elected that week,
But not
but
assumed
not
office.
not had taken office yet.
Thank you. The next bullet point past that on page 1, beginning with on vesting and process, I'm going to read that aloud to you. Quote, on vesting and process, he explained pre-app is optional. But if you elect to skip it, there is no way staff would be able to understand your application, parentheses. It would be like a foreign language, end paren, and they could therefore not determine if it was complete. Is that an accurate reading of your notes?
Yes.
Okay, so on November 6, 2017, Keith Niven explained to you that a pre-application conference is optional?
It's only optional if you don't care if your application ever can be deemed complete.
I'm sorry, could you explain that? I wasn't following that.
Well, what you just read said that he would if you didn't choose, in quotes, to have a pre-application meeting, there would be no path to having your application deemed complete. So, yes, he was explaining that the development agreement didn't require it, but that he was requiring it.
Is there something in your notes that indicate that he was, quote, requiring it?
I think the notes reflect that, and also all of the discussion and all of the communication that we had verbally with us and our consultants. It was very, very clear that if we ever wanted a complete application, then we must have a pre-application.
Looking at the specific language of your notes in the bullet point that I just quoted, and correct me if I'm misquoting this, but it appears that he is reaffirming, Mr. Niven is reaffirming that the pre-application is optional, but he's explaining the practical difficulties for staff in reviewing an application for which a pre-app had not occurred. Is that an accurate reading in your,
I don't think so.
okay, could you explain why it's not accurate?
Because I was there and had the conversation with him, and he was definitely indicating that we needed to do the pre-app if we wanted to ever get to complete application, which is obviously a step that is very important if you're trying to advance an application.
The hollow bullet point immediately following that text provides, quote, he says he doesn't know where council is at on vesting, although Stacy seems to have issue with it, end quote. So there was discussion regarding vesting at this meeting, correct?
Yes.
Who initiated that discussion?
I don't know.
His reference to he doesn't know where council is at on vesting, what was that intended, or what did you interpret that as meaning?
That he didn't know whether council supported the vesting language that staff was recommending.
And is Stacy, to your understanding, Stacy Goodman,
Yes,
was a council member at that time?
yes.
What was her connection with this issue at that time, besides being a council member, if there was one?
She might have been the chair of the Land and Shore Committee at the time. She's also an Issaquah Highlands resident and had been very vocal against development of our property for anything other than what she called the original vision.
The next bullet point, I'm going to quote this directly, says, he, again, Mr. Niven, says SDP applications vest, and that happens at preliminary application, end quote. Is that an accurate statement from your notes?
Yes.
Immediately following that statement, I'm going to read the next hollow bullet point, which provides, quote, staff has advised council members that they can make the policy decision to retroactively remove vested status for applications submitted under the DA, parentheses, except plats and building permits, end paren. Is that an accurate reading?
Yes, and to add to that, I think he was explaining to us, when he explained it as staff having explained that, he was referring to Ms. Sloman had advised certain council members of that, and he was, I perceived it as him distancing himself a little bit from having given that advice, that he was categorizing it as someone else on staff's advice.
Okay, thank you. But just to clarify, in the same meeting, and apparently right after Mr. Niven indicated that SDP applications vest at the preliminary application stage, he also said that staff has advised council members that they can make a policy decision to retroactively remove vested status for applications submitted under the development agreement, except for plats and building permits.
Yes, again, you're identifying one of the most frustrating things about the discussions that we had throughout this process was, you know, there were multiple conflicting positions that were articulated along the way.
The next bullet point at the bottom of page 1 reads, and I quote, as we discussed FAR, we suggested that if you link vesting recognition and minimum FAR together, we might be able to get on board with a proposal that averages 1, and we could even show them how future phases could be accommodated. Is that an accurate reading?
Yes.
Who is we in that statement?
Well, there are two different we's in that statement. So the first we would mean all of us in the meeting, and the second we would be Gary and I.
So the second we, if I understand the reading of this notation, is that you and Gary, on behalf of Shelter, might be able to get on board with a proposal that averages an FAR of 1? Is that correct?
So this was what I was talking about earlier, where Keith had asked us to come up with a proposal that averaged 1 FAR across the property. So he was really pushing us to do that and felt like that could, I think he felt like that would potentially resolve the FAR issue and have us stop commenting and protesting on it. So when we're talking about linking the vesting recognition, Mr. Niven had been telling us over and over again that you vest at pre-app, you vest at pre-app, but he was unwilling to put it in writing anywhere. And so what we were suggesting there was, okay, if we're going to come and get on board with FAR, then you're going to confirm in writing your acknowledgement of our vesting.
So, Ms. Heim, I am struggling with this concept, and hopefully you can help elucidate this. A minimum FAR is a requirement of the replacement regulations as they'd been proposed at that time, correct?
Correct.
Okay. If your permit, your site development permit, is vested under the replacement regulations that do not include a minimum FAR standard, why would you care about complying with the FAR standard? Why would that even be part of the discussion?
Well, our site development permits are only a portion of the total development, and they don't cover the whole property. So under any scenario, the replacement regulations eventually apply to our property, right? So we do care about the replacement regulations in all stages of their development.
There is a distinction, if I'm hearing you correctly, that you're drawing between the ASDP and STP applications that were submitted in 2017 and future FAR application to the development of other parts of your property. Is that correct?
Kind of. I think that there are the SDP applications that were pending, and that had a certain amount of development. But I think the total is in the, I don't know, 400,000 to 500,000 square foot range. And there's 1.8 million square feet of entitlement allocated to this property through the development agreement and through the plat. So we saw and see the proposed developments as one part of development, and that there's future capacity. And so I think you'll see also in these notes, there's reference to showing where more phases could go. So this was a concept where we're going, okay, well, we have these applications. You've already said they're vested. We're processing them. They're vested to the development standards that are in place now. You're coming up with these new regulations that are going to be adopted at some point in the somewhat near future. We care about them because our property will eventually be subject to them. And we were trying to manage both of those things, both the current applications which were vested, and he had acknowledged were vested, but at this point in time, he had not yet acknowledged it in writing. Later, he did.
You were at least, if I'm reading this correctly, Shelter was at least tentatively amenable to an approach under which FAR and the minimum FAR standard that had been proposed under the replacement regulations would govern future development on the Shelter property, just not the current SDP applications. Is that correct?
That was what we were discussing, was whether there was a solution that we could get on board with having an FAR. The varied FAR concept that we ended up coming forward with, it was a varied concept where it had a higher FAR on certain parcels, a very low FAR on certain parcels, so that it could accommodate retail development.
So it involved a sort of averaging model, is that?
That was Keith's suggestion, yes, that it was averaging.
Was that FAR approach ultimately adopted into the replacement regulations?
No, it wasn't. It was, Keith and I had discussed how it would be presented at the Land and Shore meeting. He had said that we would present it together and describe it together. That's not what happened. He ended up taking it and giving it to Ms. Sloman, who presented it as my proposal that was not really, the city wasn't taking a position on it at all. It ended up totally confusing the council members on Land and Shore, and kind of just didn't go anywhere because they were confused by it.
Who had suggested linking vesting recognition and minimum FAR together? Again, this goes back to which you were referring to in the bullet point that I had most recently quoted.
Our suggestion was that if you want us to do a varied FAR and come together with you on this concept, we want you to acknowledge what you keep telling us verbally, which is that our SDP applications are vested, and they vested at the preliminary land use application stage.
Thank you. Can you please turn to your November 21st, 2017 meeting notes?
Yes.
So this is also a handwritten document, apart from the date reference in the upper left-hand corner of the first page. It indicates that this meeting was attended by Keith Niven, Patrick Mullaney, yourself, and I believe Mr. Young. Is that correct?
Yes.
Are there any other attendees at this meeting, to your recollection?
I don't think so.
Did Shelter request this meeting?
I don't know.
What was the purpose of this meeting?
I'm not sure exactly. I mean, it was like many of the meetings in that period of time, talking about all of the various issues that we had and were managing with the city. So SDPs, replacement regulations, plat, development agreement.
Okay, so a global meeting covering multiple issues, as you
Yes.
understand it. Is that correct?
Yes.
There's a reference near the top of the page, or page 1, that reads, quote, "Keith, no start with default," end quote. Is that an accurate reading of your handwriting?
It is, and actually,
what does that mean?
I think that is making me remember that we, around this time, had delivered a notice of default. I might not be using the right terminology, but a notice of some sort of default under the development agreement. And so this was the meeting, I think, in response to that, based on that comment.
Okay. Do you know what Mr. Niven meant by no start with default?
That he wanted to start with the default, like no to whatever we were trying to start with. Let's start with the default allegation.
For purposes of ordering your discussion during the meeting?
Yes.
Is that correct? Okay. And then there's a reference immediately below that to 3.23.2, can process permits under the DA until it expires, quote unquote. Who said that?
I can't tell for sure. I think based on these notes and the comment below, which says, "Do you think we are not processing under the DA?" I'm guessing that Keith cited that, but it looks like a reference to the vesting section under the development agreement.
Okay, so to your recollection, and I understand that it's difficult given the format of these handwritten notes, but it's your understanding that Mr. Niven told you at this November 21st, 2017 meeting that the city can process permits under the development agreement until it expires. And there's a specific reference immediately above that to 3.23.2.
I'm not sure I would make that statement based on the notes. I can say that we talked about 3.23.2.
But you don't know who said that statement?
I don't.
Okay, but someone apparently, if I'm understanding you correctly and your notes correctly, did say that under section 3.23.2, you can process permits under the development agreement until it expires.
I don't know that that's a direct quote. I know that that's what's written in the notes. I don't really know exactly where it came from.
Fair enough, thank you. There's a statement immediately below that that reads, quote, "Do you think we are not processing under DA," end quote. What's that statement intended to mean?
I believe that was Keith asking us if we thought that they were not processing our applications in accordance with the development agreement.
So you think Mr. Niven stated that?
I think it was a question, and I think he asked it.
And immediately below that reference, there is a statement, and I'm going to quote again. "Right now, SDP prelim apps vest to DA, KN vested now to DA. Council can decide they don't like vesting lang. If council changes their mind, you start over," end quote. Is that an accurate reading of your notes?
Yes, so this is, again, the same thing we've talked about a bunch of times, where they're saying you're vested.
You say,
The city is telling us that we are vested now to the development agreement because we have the preliminary applications that are complete. And again, then they're suggesting that the council could decide to retroactively take that vesting away, which we vehemently disagree with.
So if I understand you correctly, Ms. Heim, Mr. Niven is stating your notes and your attempt to capture his statement that according to Mr. Niven, shelter is vested as of right now or right then to the development agreement, but that the council, in Mr. Niven's view, can decide that the council doesn't like the vesting language. Is that the staff proposed vesting language?
Yes.
And if the council changes their mind, you as shelter will start over? That was Mr. Niven's position at this meeting?
It was a position that he articulated at the meeting, that it was based on a fundamental misunderstanding of
Yeah,
what
but that's what
vesting
your
means.
notes say, correct, in terms of what Mr. Niven was communicating to you at this meeting?
That's one of the things that he communicated
Thank
at
you.
this meeting.
Immediately below that reference, there's another statement reading, quote, Haney says you are only vesting to contract period. City attorney is the one not willing to, quote, end quote. Haney, again, from the context in your previous testimony, would be Jim Haney, the Issaquah city attorney.
Yes.
What is that statement intended to mean, and who communicated that statement?
This was, again, something that Keith would repeatedly tell us, that he was getting advice from Jim Haney, the city attorney, that said vesting only lasts to the contract period. Again, we always disagreed and always asked for conversation with Mr. Haney and never got any response, and also never saw any response publicly to the questions that were being asked by council members in the process on these issues.
So the reference to, quote, city attorney is the one not willing to, what does that mean? Not willing to what?
I'm not sure.
Okay, thank you. The next statement in these notes reads, quote, council is told they have a choice. They are deciding, end quote. What is that in reference to?
That's in reference to the idea that staff had advised council that whether to continue to recognize vested permit applications was a policy decision that they could make to retroactively remove vested status.
Thank you. The next statement in this series of notes is, quote, we want to see acknowledgement that apps are vested, end quote.
Yes.
What was that statement intended to mean?
That was us asking yet again to see acknowledgement in writing that our applications were vested. And I think in this meeting, later on in the notes, Keith suggested to us that he would do that. He just needed us to send him an email calling out the permit applications, and that he would confirm via email.
Thank you. The next statement reads, quote, Patrick suggests use the plat to link vesting plus mitigation dash Keith, end quote. Is that an accurate reading?
Yes.
What is that intended to mean? And Patrick, I'm assuming, is Patrick Mullaney from the heading?
Yes.
Thank you. What was the reference there intended to mean?
I think because Keith was suggesting to us that he agreed with our positions about vesting, that Patrick was suggesting to him, you need to look at the plat and what vests through the plat, which should be the development that's shown thereon, and that gets you to, that provides the link of vesting to both the development and the mitigation through the development agreement standards.
As of the time of this meeting on November 21st, 2017, did Shelter's preliminary plat application show building footprints?
It showed allowable development allocated block
Showed
by
building
block.
footprints?
I don't believe it did.
At the bottom of the page, there's a reference to, quote, Jim working on written response, end quote. Is that a reference to Mr. Haney?
Yes.
And the written response is in specific response to,
I'm not sure. At that point, there were various letters and emails that Patrick had written to Jim and contact attempts that had been made. So I'm not sure which that refers to.
at the top of the next page, there's a statement that reads, quote, what are vesting events and confirm we've, end quote.
I think that's obviously an incomplete sentence, but it's referencing to what I was describing before, which was that Keith suggested that we send an email to him so that he could confirm we've vested.
Okay, so just to clarify, Ms. Heim, the statement that I just read was your suggestion to Mr. Niven?
Well, I mean, this isn't like a transcript, so
Sure.
it's my notes. I believe that these notes are referring to the discussion that we had at that meeting, which was that Keith suggested we send him an email describing where our permits were and that he would confirm that they were vested.
Moving down in the document, there's a handwritten heading entitled Appendix L. Do you see that?
Yes.
And a reference immediately following that that reads 9.1, default complete application after 10 days, KN, colon, whatever you give us is a pre-app is complete, end quote. Is that an accurate reading?
Yes.
What is that intended to mean?
I think it's part of the larger discussion on the status of our applications. And so we were talking about the fact that the development agreement has a 10-day period after an application within which the city can request more information if the application's not complete. And since we were beyond that period for all of our preliminary land use applications, he was acknowledging that whatever we gave them for pre-app was at this point deemed complete.
Did Mr. Niven or any other city staff member follow up with any sort of written confirmation to that effect?
Yes.
Is that documentation in the record for this hearing?
Yes, I believe so.
The next statement reads, send email to KN based on App L. Have these apps submitted on these dates deemed complete?
Yeah, so this is that same reference to the same concept that we were discussing, which was that I was to send him an email that listed out the applications, listed out the dates that they were submitted and the dates that they were deemed complete, and that he would confirm that they were vested.
And did you send that email?
Yes.
Was that your November 6th email? 2017, that's in the record?
No, it's a November 22nd email, and he responded and confirmed that they were vested.
The next reference is entitled Outside DA. Do you see that?
Yes.
And the immediately following text is, quote, SDP pre-apps vested under city code, end quote. Is that an accurate reading?
Yes.
Who said that?
Mr. Niven, he described that throughout the city, the administration's position was that SDP pre-application or preliminary applications vest because they're linked to the building permit process.
Did Mr. Niven cite any municipal code or development agreement sections in support of his statement, to your knowledge?
I don't think so, but, he's the Director of Development Services, so we assumed that he knows what the city policy is regarding site development, permit applications, and vesting.
The next statement in your notes reads, quote, KN colon, mitigation plus vesting are not connected. City could pull vesting and acknowledge mitigation, end quote. Is that an accurate reading?
Yes.
And from the context, is it true that that statement was made by Mr. Niven at this meeting?
Yes.
Okay, so in light of what I just quoted before that, Mr. Niven's comment apparently that SDP pre-apps are vested under the city code, Mr. Niven apparently immediately following that statement then said that the city could pull vesting if it wanted to? Is that
Oh.
what your notes indicate?
No, I don't think that's what it meant. I think he was talking about pulling the vesting language out of the replacement regulations.
Is there anything in this document, your notes, that indicates that this was a reference to the replacement regulations?
No, but again, these aren't a transcript. This is
I understand that.
being
Is there
used to
anything
help
in the
jog my
document
memory.
that
So
say
it's,
that?
I'm responding based on my memory that's being jogged by looking at my notes from that meeting.
Okay. So in that context, if I'm understanding you correctly, Ms. Heim, Mr. Niven was referring to the city council's ability, under Mr. Niven's theory, that the council could pull vesting out of the replacement regulations and simply not address it at all? Is that what you meant?
I think well, I don't know if that's what he meant, but my understanding was that he was saying that they could pull the vesting language that was currently being proposed at that time. He didn't get into what it may or may not be replaced with, but that the city could still acknowledge mitigation.
Are you aware of any draft or iteration of the replacement regulations that specifically addressed mitigation that had been provided during the term of the development agreement?
Well, that's kind of a tricky question, because if you are acknowledging vesting through the development agreement, which the earlier version of the vesting language that was proposed did, then you are also acknowledging vesting of mitigation, because the development agreement is explicit that mitigation is part of the development standards to which you vest.
Forget about the tricky question aspect, which is not my intent. I'm just curious, does the word mitigation appear in any of the iterations or drafts of the replacement regulations that you saw or you were aware of during the legislative process for the replacement regulations?
I really don't know whether the word mitigation appears in any draft. If you're asking if there was an effort to globally address mitigation in the development agreement, no, I never saw that.
Thank you. The next statement in your notes reads KN, and I'm struggling with the next word, but I believe it begins with a G. Council keeps vesting language and Haney says mitigation disappears, end quote. Is that an accurate reading? And could you please tell me what that word is intended to mean?
I think what it says is KN guess, and then council keeps the vesting language, and Haney says mitigation disappears. So he was telling us that what he thought was going to happen was that the council was going to leave the vesting language as proposed by staff, but then that Haney would take the position that mitigation disappears. Obviously, that's a very strange position to take if you are familiar with the development agreement, because mitigation is specifically included in the development standards to which you vest under the
And
development
this is what
agreement.
Mr. Niven had estimated, or I guess quote-unquote guessed, that the council would ultimately do with the replacement regulations, is keep the vesting language that the staff had proposed, but that under the city attorney's position, even if they did that, the mitigation that had been previously provided during the term of the agreement would, quote, disappear? That what was communicated to you at this meeting?
This was his prediction as to what he thought was likely to happen.
And the next statement reads, quote, Keith says mitigation not part of dev standards despite it being in definitions, end quote. Is that an accurate reading?
Yes.
What was that intended to mean?
Keith took the position that mitigation was not part of the defined term development standards under the development agreement, even though the words in the development agreement are very clear that it is. So this is one of those situations where it puts us in a very awkward position when you're having a discussion with somebody that refuses to acknowledge something that is obvious to everyone else in the room.
Next statement reads, quote, only vesting to dev standards, rest of DA disappears, only LU standards, end quote. Is that an accurate reading?
Yes.
What does that mean?
That's, again, the position that he was articulating.
And he was Keith?
Yes.
And what was his position? What was he articulating with that?
He was making this argument that you vest to development standards, but the development standards doesn't include mitigation. It's not what's in the development
Can you
agreement.
explain the
and
basis
it's
for
not
that?
Zach, I haven't objected a number of times, but you keep cutting her off in her answers.
I'm sorry, I thought that she paused in mid-statement. I'd be happy to slow down a little bit. Do you have something else to say, Ms. Heim?
So this whole issue is that if you don't actually read the development agreement and you're just saying, well, development standards, in my mind, doesn't include mitigation, that's what Keith was doing. He wasn't actually looking at the development agreement. And so this was a conversation that we had with him. It doesn't make a lot of sense if you're following along with the way that things lay out, but it's what was happening.
The next statement from your notes is, quote, question is to what you vest, period, end quote. Is that accurate?
Yes, that's what it says.
Who stated that?
I can't tell from the notes.
Okay, if you have no recollection of that, that's fine, I'll move on. But that, to your knowledge, that wasn't a question posed by staff or yourself?
Well, I mean, the whole discussion was all about vesting and to what you vest. So, yeah, somebody was saying that. That's the whole topic that we're discussing. I mean, the city was going so far as to say that even issued SDPs would unvest and unissue, which was...
And I think that's the next reference at the top of the next page, if I could have you look at that. The quote is, issued SDPs will disappear under option 3, EC contract expired. Is that what you were just referring to?
Yes.
And was this an acknowledgement by Shelter, or was this a statement by Mr. Niven or some other meeting attendee?
This was a statement from Mr. Niven, and option 3 refers to the options that were laid out in, I think it's a November 16th memo that staff wrote. I don't recall whether it was Mr. Niven or Ms. Sloman. It's already in the record somewhere. But I believe option 3, well, I don't know which option it was, but it was not the option that had the proposed vesting language that acknowledged vesting of the land use permit applications and the site development permit applications. So basically Keith was telling us that if council chose to modify or take out that language out of the replacement regulations, that SDPs issued under the development agreement would disappear and not be valid anymore.
And the reference, if I understood you correctly, Ms. Heim, was not to applications, but actually issued permits?
Yes.
And that was under option 3?
That's what he referenced it as in that meeting, yeah.
And your next statement, if I'm reading this correctly, if the reference to TH is to yourself, is, quote, "If you choose option 3, your delay has prevented us from vesting," end quote? Is that accurate?
Yeah, so this,
I'm sorry, did you express that to Mr. Niven? Is that a statement that you made at the meeting?
yes. So we were telling him, or I was telling him, that if they do something other than acknowledge the vesting or continued vesting of our projects, that the city's other defaults under the development agreement for failing to process in accordance with the timeframes that are spelled out in Appendix L would have caused us not to get to whatever that new point of vesting was that they were going to establish. So we still firmly were of the opinion and still are of the opinion we are vested. But we were telling him that if you take some other position, not only is that position itself not legal, but you also have intentionally delayed our permits, and all of this delay and failure to get to whatever point you're telling us we should have gotten to is your fault.
And you conveyed that to Mr. Niven at this meeting?
I did.
Did he respond?
I mean, there was discussion of that. This was a meeting, this was one of the meetings at which he then referred back to the fact that Gary didn't give him the property for the college years before, and he called it a pivot point, and said that there were many pivot points in this process, and had Gary made a different choice, that we'd be treated differently.
And that reference to these pivot points and the prior property issues with the college, that in this document, in your notes?
There is a reference to pivot points and could have let us do the college. That is something that part of the conversation is quite clear in my mind, because it was so appalling to me that a government employee would sit there and look at a property owner in front of 2 attorneys and say, "You didn't give me something I asked for, so now I'm treating you differently." It was shocking.
Next reference in your meeting notes reads, quote, "not funded to Appendix L," end quote. What was that intended to mean?
So this was another one of several arguments that Keith made to us about why they weren't required to follow the timeframes in Appendix L.
I'm sorry, could I interject just briefly to a clarification? So that statement was a statement or paraphrase from Mr. Niven?
It was yeah, sort of. I mean, it was a topic that we discussed, so it was something that he brought up, that he said they were not funded to follow Appendix L. And he said that originally under the development agreement, the master developer, Port Blakely, had funded an entity that was called the MDRT, and I don't remember what that stands for, but it was basically a permit review entity, a branch of the city, if you will, that reviewed all of the permits in Issaquah Highlands when it was sort of at the height of its development. And that MDRT was funded by the master developer. At some point, the master developer discontinued that funding mechanism, and the permits started being processed by the city staff. Now, some of that MDRT staff actually rolled in and became the city staff, but he was of the opinion that when that funding stopped, that he didn't have to follow the timeframes in Appendix L any longer. There's no evidence in the documents as they are or as they were amended that that's actually true. And we did follow up with the master developer and the master developer's attorney to clarify that that's not true. And they confirmed that Appendix L was in fact in effect, and that there was, although there had been a short time period in which a different arrangement was tested out, that arrangement had expired, and that Appendix L was in effect, and the city was bound by that, as were we.
Thank you. Could you then turn to your December 12th, 2017 meeting notes? Mr. Chairman, this will be my last series of questions for this evening, if that's permissible to you. I think it would be a good breaking point, and we're getting close to the 10 o'clock hour.
Let's go.
And this will not be very long. The attendees at this meeting, Ms. Heim, as I understand it from your notes, were Ms. Sloman, Jean Lynn, Mr. Schlepp, David? Is it
David
Holmes?
is David Holmes at, oh, it's too late. I can't remember the name of, I'm blanking on the name of our consultant, but our architect.
Alter consultant.
Yeah, David and James are both at the architect. Alan is at the landscape architect, and Riley was with KPFF, the engineer.
Thank you. And the title of this document is a Block C Pre-App Office and Fitness. Could you describe the purpose of this December 12, 2017 meeting?
Yes, this was the required preliminary application meeting for the office and fitness proposal on Block C.
Was there any discussion regarding vesting at this meeting?
I don't see any reference to vesting in my notes.
Thank you. I think that would, again, be a very logical breaking point. I do have probably, I would estimate, an hour and a half or so of additional questions when we reconvene at the next meeting.
I'm sorry. Would you say that again, please?
Again, this would probably be a logical breaking point for purposes of our cross-examination, and I would estimate approximately an hour and a half to maybe an hour and 45 minutes of additional questioning when we reconvene.
Thank you. Duly noted.
I actually have one quick question for the record before we turn this into the city. Is it just ministerial? The issue we had with the letter that was, I think it was part of S73. I just wanted to get clarification. Jackie, I think you might be able to do this. Is there, as far as in what you guys intended to submit, an S73N? I'm not seeing it in the notebook, and we discovered it was a duplicate on our end, and so I just wanted to get some clarification on that before I give this to the city clerk.
Let me check for a second and see if it can help with that.
73N?
No, I have it. It appears to be the exact same letter as S73J, and that was my initial question, and then it didn't appear in the notebooks that the applicants.
So I think that's right, and if I recall, and I apologize, 'cause we don't have a transcript from last night, so that it would clarify, but I think that was the exhibit that we were having the shuffling around on.
Right.
So I think that we decided not to use N in that exhibit because
one.
we recognized it was already a duplicate.
Okay,
Yeah.
perfect. I'm going to pull it. I just wanted to make sure that wasn't
Okay.
appropriate. Okay, thank you.
Thank you.
Okay, I think we've reached the agreed upon time, or close to the agreed upon time when the meeting would be adjourned, but therefore we'll be continuing the public hearings on tonight's agenda to a further meeting date, and we need to decide the dates for our next meetings. And I understand that the parties may be available to continue these hearings to the evening of March 19th and 20th. Is that correct?
You're available.
Okay. Commissioners?
I'm available.
Excellent. Okay. The public hearing on tonight's agenda will be continued to a special meeting of the commission on March 19th, 2019 in the council chambers at 6:30 p.m. The meeting is now adjourned. Not adjourned. Sure.
Given that I believe that we're coming near to the point where I think it would be appropriate to schedule the public testimony portion of the public hearing, since we won't be meeting in the near term until we reconvene on the 19th and 20th, I certainly foresee concluding my cross-examination of Ms. Heim on the 19th, and I would have to defer to the applicant as to how much additional direct witness testimony will be required. But it might be a good idea to schedule the public testimony portion of the hearing for the 20th, so then the parties can schedule one last go-around for purposes of the rebuttal. That might be more expedient. Not my place to advise you, but I'll just throw that out there for consumption of the commission.
Okay.
You might ask how many more witnesses they plan to.
Do you have a large number of witnesses to come forward?
We have one more witness that we'll call. And I think that our ability to get through that witness with the city's cross-examination, if they're going to do a cross-examination and a redirect of each of our witnesses, it's just going to depend on how much longer the cross of Ms. Heim takes the next time. So we can try to get done in that period of time, but I don't know how the timing will actually work out.
My experience with you all is that time is not a real strong value for you. I mean, I know you think it's important, but it's not easy to predict. I don't want to bring the public here and not be able to have time for them to do that. So my guess is you're probably going to take the 19th and part of the 20th. Can you advise me otherwise?
That's fine, and I appreciate the concern, and I think that your characterization of our respective estimates of timing is probably accurate, if I can malign my own. So I have no objection to that. I was, again, just attempting to expedite the process. So I'm fine with that, and certainly the commission can schedule the public testimony portion of the public hearing when we reconvene later.
So I apologize. I'm not sure, in light of these last comments, whether we're all on the same page about expectations. So my assumption is on the 19th, we'll finish up with Ms. Heim and perhaps with Mr. Young. And then is the city intending to call rebuttal witnesses? And if so, is it your thinking you'll do that before or after the public testimony?
Is your microphone on?
It's been my understanding that the rebuttal testimony would occur after the public hearing, so the parties would have the opportunity to rebut any statements that members of the public might make. Whether and to what extent the commission chooses to schedule that public testimony to occur on, for example, the 20th is your prerogative. I was just suggesting that as one option to ball rolling, as it were.
I appreciate that.
Well, certainly it seems to me that if the rebuttal testimony is coming after the public hearing, then we should schedule the public hearing on the 20th. Otherwise, we're likely to have an evening we're not being terribly productive with.
That was my point.
So we would concur with that suggestion.
Okay.
I would agree with that.
Sounds like the best guess at this point is to schedule public input on the 20th and to expect the cross-examination and the redirect to be completed on the 19th, and then the redirect would be at a further meeting after the public hearing. Is that correct?
I'm understanding Mr. Schneider's comments and the commission's preference. What would occur on the 19th would be a completion of the city's cross-examination of Ms. Heim any redirect of Ms. Heim by the applicant, then they would call, if time permitting, Mr. Young as I believe their final witness, and then any cross and redirect of that witness. And then the 20th would be reserved for the public hearing, and as well as any carryover from Mr. Young's testimony.
And I don't have any sense whether the public hearing is going to last 5 minutes or 2 hours. So unless there's some ability to predict the length of it, then I would suggest that the city be prepared to put on its rebuttal testimony with whatever time remains on the 20th, if there is going to be rebuttal testimony.
We might be prepared to begin that, but my strong assumption, given the length of Ms. Heim's testimony over the last 5 hearings and Mr. Mulaney's testimony, that it would be that our rebuttal witnesses would consume likely an entire session in and of themselves.
So give me a recommendation. Should we try to hold the public input on the 20th public hearing portion of the meeting? It sounds like we should do that.
Yes.
Yes.
So let's try to get that scheduled, make sure that the public knows that that's their opportunity to be able to comment. That sound good?
Yeah.
Is it all right if we adjourn now? We're adjourned.